Right. Welcome, everybody, to another episode of The Compliance Guy. My name is Sean Weiss, and as always, I want to start off by saying thank you to each and every single one of you who are tuning in live on LinkedIn, Facebook, YouTube. And for those of you that are going to be listening to our recording of this live presentation on one of more than 80 different podcast platforms, thank you as always for taking time out of what I know is an extremely busy schedule to tune in and listen to what it is that I and my special guest, or in this case today, my very special guest, um, are talking about. I'm really excited to be able to talk about this topic because obviously there's a lot going on with information blocking. I think there's a lot of misperceptions. There's some misunderstandings. There's a lack of cohesive explanation from the government as to where information blocking actually fits. There's a lot of folks that think it falls under the Health Insurance Portability and Accountability Act. So today we're going to take time. We're going to cover in great detail what information blocking is, where it came from. We'll talk about examples of what information blocking is. We'll talk about the civil monetary penalties. We'll talk about who actually is responsible for the enforcement of information blocking. And then I also, because we continue to be in the middle of a public health emergency, which doesn't seem to want to let loose of the world for the most part. But again, there's a lot of misperceptions. There's a lot of misunderstanding. There's a lot of bad information going around about whether or not your vaccine card is considered protected health information. Thus, is it covered under the Health Insurance Portability and Accountability Act? And I think some folks are going to be very surprised with the answer that our guest gives today. So real quick, let me go ahead and introduce a lady that needs no introduction at all as far as I'm concerned. Amanda Waesch, she's been on the Compliance Guy program in the past. I brought her back, one, because y'all asked me to, but two, and more importantly, because I just love having conversations with this lady. She's just a consummate professional. She's become a great friend to myself over probably now, I think, the last 6 years that we've been able to work together on a variety of cases and in different capacities, speaking engagements. So for me, it's such a pleasure. So let me just introduce you to this outstanding individual. Amanda is the vice president and member of her firm's executive committee, as well as serving as the marketing and business development chair. Amanda chairs the firm's litigation team that handles all reimbursement audits and appeals and heads up BMD's provider relations, audit appeals, and negotiations unit. They got a real fancy acronym for it. Now, I also want to let everybody know that Amanda has been named for 2022 in the 28th edition of the Best Lawyers in America. I voted for her like 27 different times under pseudonames and things like that. Because she's really she's incredible. And for those of you that tune in and you watch the Compliance Guy show, I'm not joking. And I'm so blessed to have people like Amanda, Ron Chapman, Robert Lyles, Brian Meek, and the list goes on and on of just these outstanding health-centered attorneys that really take time out of their busy schedules to provide our audience with just the latest, greatest, and most authoritative information that is available. I want to give a little bit more of a shout out to Amanda, and I know she, is probably going, please don't do that. But it's so impressive knowing what she does every single day, but the things that she also has time for. So let me just give you a quick rundown. She's with the Rootstown Local School District Board of Education for the Student Achievement Liaison. She's was the president in 2019 and 2020. The University of Mount Union Alumni Association, the executive board member, alumni weekend and awards committee chair. One of my favorite societies, one of my favorite ones, the National Society of Certified Healthcare Business Consultants. She's the education committee chair. I have to beg Amanda to let me present. The American Heart Association, Portage Summit County Board, Go Red for Women 2021 campaign chair, University of Akron, College of Business Administration, HR leadership advice. I mean, I'm exhausted reading about it all. But because I know who she is and how she operates, it doesn't surprise me all of the things that she's able to take on. So again, Amanda, welcome back to the show. Thank you so much for being here. I am so excited to have this opportunity to chat with you today. And I know our viewers are like, Sean, okay, enough already. Let's hear what your expert has to say.
Oh, thank you, Sean. I'm always so humbled to present with you. And not only are you a good friend, but a fantastic colleague. And I mean, you're a healthcare nerd just like me. So I love, debating these new laws and new guidance and how is it going to be applied to providers. So I'm really excited for our conversation today because we have a lot of meat to get into, and it does dovetail nicely into what we're experiencing on a day-to-day basis as an individual or as an employer or as an employee. So I'm really excited to get into the meat of this with you. And you and I have had several conversations, but now everyone gets to listen to the conversations that we have almost on a daily basis. So thank you again for having me.
Yeah, I'm so humbled and privileged to have you on the show. So let's go ahead and get right into this because, again, like you said, there's so much to be able to talk about. And really, I guess the most natural place for us to begin is by talking about information blocking. Really, what is it and where did it come from? Why are we having so many discussions right now about information blocking?
So information blocking is a relatively new term for us as providers because the rules were just passed in the last year. But this is something that's been evolving over many different administrations and over several years. So information blocking was actually passed as part of the 21st Century Cures Act back in 2016. So I'm going to ask you to take and go back 6 years and remember where we were from an administration and policy perspective. And the statute was actually passed in 2016. Well, in May of 2020, we had final regulations implementing the information blocking rules be published. Well, what happened in May of 2020, we were in the middle of a pandemic. Nobody was paying attention to these rules that were published. And so the rules were delayed until November of 2020. Again, still in the middle of a pandemic, in the middle of the second surge. And so the rules were delayed until April of 2021. So for those of you that are hearing information blocking for the first time today, and you're a healthcare provider or you're an EHR vendor, know that you were required to comply starting April of 2021. So information blocking has been around since 2016. We've been anticipating that these regulations were going to come to fruition. But unfortunately, they came to fruition in the middle of the COVID pandemic and have been largely pushed aside. And for providers, I get it. It's one more thing for us to read and to worry about and implement. And it's not, it's not a fire for them. It doesn't rise to the level of some of the other issues that they're looking at on a day-to-day basis.
And I agree with you. They're not, but they need to be. Because
unfortunately, yes, that's the nature of healthcare, right?
Yeah. I mean, that's the nature of the beast in the industry that we work in, right? And there are extreme civil monetary penalties that we'll talk about. I mean, these things get up into the 7 digits, if I'm not mistaken. But right. I feel like really, information blocking, obviously, yes, we need the providers to be able to look at their documentation, to review it, to make certain that the I's are dotted, the T's are crossed, that we're not potentially releasing any information that could harm the patient or another person if information was given about that person. But I feel like the onus is really on administration when it comes to the information blocking, right? Because it's not the doctor who goes and makes a copy of the medical records. It's not the doctor who gets the request, the authorization for release of medical information. It's the Health Information Management Services Department of a hospital or a health system. It's the medical records department of a physician practice. Would you agree with me? Even though the fine goes to the provider and or their organization, it's still a group effort to make certain that we're complying with the information blocking rules.
Absolutely. It's definitely administration. So it's your health information, medical records department. It's your compliance department. It's also your IT department, because if you get a reasonable request, to submit records in a certain format, you have to evaluate whether you can comply with it. So you want to involve IT, and you want to look at all different access points where patients can request copies of their medical records, or where payers can request copies of medical records, or employers. So they may be requesting via fax. They may be going to the front office staff and saying, I need a copy of my medical records. You may get an email. It may be through the portal. So you got to look at all of your different access points and make sure that you have a flow process and a policy, and that you are timely complying, and that you're documenting the process. And so the easiest way that I can think of it, from a process standpoint, is to, one, involve all of your stakeholders, take inventory of all of your access points, your IT capabilities, what your flow process is now, and tweak that flow process to make sure that it's compliant with not only HIPAA, but also the information blocking rules, and then do some training and education. And you want to monitor it as part of your compliance program, just like you would HIPAA or any other request. So there is some undertaking and some planning that needs to go into this on the provider side. And some providers may think, well, this is just like a HIPAA request for information. I get an authorization. I've got 30 days to respond. Well, it's not. It may be easy for some providers, but think of a provider that has multiple locations, or may have multiple EMRs. So they've got an imaging center, and so they've got records that lie in the imaging EMR. They've got an ASC, or just a physician office, and so how those systems talk and interact with each other, and how you respond to the request could implicate these information blocking rules.
Yeah, I think those are all great points, and especially taking into consideration providers that have satellite locations.
Right.
They have vested interest in an ASC, in an IDTF, or
right.
Something like that. But let me ask you this question. Do you think that information blocking was brought on because health systems, hospitals, physician practices were derelict, if you will, for lack of a better term, with granting access, but also granting access in a timely manner to patients?
Yeah. So when we look at the evolution of the policy, right, we start with HIPAA. We're going to protect this information. It was grossly being abused, and individuals, their privacy rights were being violated. So here we have the introduction of HIPAA. Then we were evolving from a paper-based society to an electronic-based society, and we have the evolution of high tech. And then we have the evolution of now we've got to, share this information and provide access to this information. So we have the health information exchanges and networks, and not all of the EMRs talk to each other. And now we have requests for information, and not everyone is complying. And some may be, just not responding at all, or they may be taking their good old time, or they're saying, hey, this is the format that I'm giving it to you, and if you don't like it, too bad, so sad, even if it's not readable or if it's not usable. And so now we have the Cures Act that's saying, look, we want you to give this information. We want to share this information freely. And you can't engage in a practice that materially prevents or blocks an entity or an individual's right to this information, you can't engage in that kind of conduct. And I think what was happening is when we look at the Office of Civil Rights, which is the branch of the government that enforces the HIPAA rule, both the privacy rule and the security rule, they're getting complaints, all different types of complaints, such as, the privacy rule was violated, because they sent my records to the wrong patient, or someone stole my medical records and the hospital, didn't take action to protect them, and I want an investigation done. But I think a lot of their complaints were, I requested my medical record and I didn't get it. Or a provider, I'm trying to get information from my EMR vendor and they won't give it to me. Or employers, payers, requesting information to be able to process workers' comp or process claims, and they're not getting it. And so we have all these stakeholders that need access to this information, and they're not getting it, and OCR is getting inundated with these requests. And so we have this information blocking, which again is the evolution of, we want this information to be freely shared and available on these networks and exchanges, and we're going to hold individuals accountable. And this is a law that is separate and apart from HIPAA. It complements with an E, HIPAA, and so we have to think with both of our hats on, our HIPAA hat and our information blocking hat on, to make sure that we're compliant with both. But I think it's just an evolution of policy and a response to what we're seeing in the marketplace.
Yeah. And, one of the things that I thought was really interesting, you did a PowerPoint presentation. You gave a lecture on information blocking. And, you just talked about some of the key terms of the definition of information blocking. But if I can take yours, because there's one word that kind of actually sticks out to me, and it makes me think in terms of another act with how they use this term. And here's what it says. Information blocking is defined as any practice that is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information, and if conduct by a healthcare provider, such provider knows. That reminds me of the False Claims Act, right?
Ding, ding, ding. Yep.
Ding, right?
That's the standard in healthcare. You can't be the ostrich in the sand, right? You either know, so you have actual knowledge that what you're doing is wrong, or you should know. Know. And so you have a duty to inquire, a duty to educate yourself, and a duty to conduct yourself accordingly. And that's where your compliance program, ongoing auditing and monitoring, and education and training, that's why it's so important, because we do not want to be the ostrich in the sand saying, hey, I didn't know, so I can't be found liable. That is not the standard in healthcare.
Well, so I was going to ask you to give some examples of information blocking, but I think what led you and I to actually saying, hey, we need to do, or me saying to you, hey, Amanda, please, will you come on and do this with me? We had a client.
We had a case.
Yes, we have a case, and it's turned into a bit of an ugly case. Mm-hmm. And real quickly, I want to be cautious because this is an ongoing legal issue. But this client engaged a third-party vendor who was offering a service, was offering machines that provided certain types of, medical treatments for patients. Unfortunately, the device that the provider was using was considered to be experimental and not medically reasonable, appropriate, or necessary. That's another part of the issue. But as part of engaging with this third-party vendor, they had to agree to use a specific practice management system and a specific electronic medical record system. Am I correct so far? Okay. And it was sort of a perfect storm, because the client was going through an active investigation from a special investigative unit from one of the commercial insurance companies. And we needed to be able to respond to the request for additional documentation. And the problem was our client's access had been shut off into this PMS and EMR system, thus basically crippling us as the legal team and preventing us from complying with the insurance company. So let me stop there and let me kind of have you share the finer details of why this became an information blocking issue and sort of the route that you had to go to try to cure this issue.
Sure. So I had a similar issue. We'll go with the tale of two providers. I had a similar issue to 18 months ago where a provider needed to respond to a request for medical records. It wasn't as egregious as this case where this was an actual SIU investigation. But there's a request for medical records. The provider has the burden of producing the medical records, and there are ramifications if they don't do that. And it's not enough to go back to the requester and say, I don't have access to the software. My vendor's not cooperating, because the government says, hey, not my problem. You chose the vendor, not my problem. So when I had this situation arise with a provider 18 months ago, I went to the HIPAA security rule that said vendors cannot hold this information hostage, right? Because if your contract ends or if you're demanding payment. Now, if the vendor is going to demand payment, it has to be in the contract. So you have to contractually agree to it. Vendors are now getting sophisticated, and usually there's some kind of payout if you want your data extracted, or you've got to do it before the contract terminates. But it is a violation of the HIPAA security rule if vendors do not give the information back to the client, because it's the client's proprietary and confidential information. So
and let me stop, because I know we have vendors who are listening to this, and I need you folks that are listening to pay very close attention to this, because holding your client or ex-client's medical information hostage in lieu of getting payment, you're in violation of the Health Insurance Portability and Accountability Act security rule.
That's right.
Go ahead.
So my recourse was to go onto the Office of Civil Rights, which is, again, the arm that enforces HIPAA. There is no private cause of action. So I had to file a complaint saying that this vendor had violated the HIPAA security rule. Now, I knew that OCR wasn't going to look at it for 12 months because that's how backed up they are. It may be even longer than that now. So fast forward, we have the final rules for the information blocking. And when I have the same issue pop up for our mutual client, what did I do? I filed a complaint with OCR for a violation of the security rule, but then I was also able to file a complaint with the ONC, the Office of National Coordinator, which is the arm of the government that is in charge of information blocking. And so now I've got kind of two complaints that I filed on the same similar conduct. And the client's in a much better position now that these rules have been implemented. And ONC, they're ready. They're ready to take these complaints. Their website is up and running. They're responsive. So from a provider perspective, if you're in that situation, you can now file complaints with ONC and OCR. Patients are going to be made aware of this pretty soon. And then to your point, Sean, if you're a vendor, you really need to pay attention to your contracts and review them because we don't want you to get in trouble.
Absolutely. And I think the other thing also that vendors need to be very mindful of is don't try to play games and provide the information in a format that only your system can decipher. It needs to be provided to your clients in an easy, readable format. And that was part of the complaint that we had in the case that you and I were working together. Going back, at least a half a dozen times you had to go back to the opposing side's counsel and say, no way, guys, this data is unusable. We can't read it. We can't disseminate it. We can't, submit this to the insurer. And it was just a merry-go-round. So it's not like, and I want folks to understand, Amanda is not the type of attorney that says, do this one time or that's it. Amanda will send you multiple letters. Each one's a little bit more to the point.
Scathing than the previous one.
Yeah. I always tell Amanda I never want to be on the receiving end of one of her letters because I will be responding to the very first one. But the truth is, you gave counsel multiple opportunities to comply with the request. You cited the specific statutes, the laws, the act, the requirements, even the state laws that said they had to release this, and they just kind of jerked around with it, and it came down to you saying, all right, you know what? Fine. Office for Civil Rights, ONC, and just so everybody knows, it's the Office of the National Coordinator for Health Information Technology. That's the full name. We call it ONC for short, but it's Office of the National Coordinator for Health Information Technology. So again, vendors, don't play games with this stuff. To the hospitals, the health systems, the physician practices who are listening or watching this this live broadcast, folks, you've got to respond in a timely manner. And Amanda, can you address what is considered a timely manner?
Right. So under the HIPAA rules, we have 30 days, right, to get everything together. But for the information blocking rules, they want you to respond within 10 days and let the individual know whether you're working on their response or whether the response is not feasible to comply with. And so for most responses, you're going to be working on it, right? It's going to be a patient request for information, an employer request for information, payer request for information. And typically you're going to be able to give the information through the portal, or they're going to be able to access it through the portal, or you print it out, or you fax it. They're going to be your typical requests. But I think that when we get to more specific requests, like a payer is saying, we no longer are going to accept faxes, so now you have to submit information up through our portal, or you've got to have an interface with our portal. We'll pay for the interface, but you've got to have an interface with us that we can freely exchange this information. It's at that point where if providers are like, no, we're not doing that. We're not going down that road. We're not going to turn on the interface. It's at that point where you can run afoul of the information blocking rules. Maybe you're not running afoul of HIPAA, but the information blocking rule says within 10 days, you've got to say, okay, I'm working on this request, or I can't do this request because it's not feasible. And feasibility is limited in scope. So feasibility is like a natural disaster. We had a earthquake, we had a hurricane, and our systems are down and we don't know when they're going to get back up. But here's a reasonable time frame. I can't get back to you in 10 days, but here's a reasonable time frame. Or we just don't have access to that technology, and it's going to cost us money to get access to that technology. What wouldn't be acceptable is, we can turn on that interface. We just have to flip the switch. We're not willing to do that. So that's why you've got to involve your IT team to discuss, feasibility. Obviously, HIPAA still applies. Like I said, these rules complement each other. So if you're not able to give the information up because it would be a violation of HIPAA, so you don't have an authorization, or it's violating state law or federal law, or maybe you're on litigation lockdown, you've got a legal hold on it, or it's a psychotherapy note. So there are exceptions. It's just that we need to make sure that you're documenting that you're compliant with the timeline, that you're discussing, can I give this information? Is it feasible for me to give this information? And you're logging it just like you would log requests for HIPAA information or potential breaches, so that if you are investigated later and you are asked the question, what happened? You have documentation as to what happened so that you're not piecing it together a year later. So that's why it's so important to have that policy and have that flow process and have the documentation.
So you went right to one of the areas where I wanted to go, which was talking about, whether obviously you and I are are huge advocates for organizations having effective policies and procedures.
Absolutely.
And having a policy on information blocking is critical.
Yes.
And for me, what I'm hearing from you is one of the key components that should be outlined in your policy is that you have 10 days in which to issue a response to the requester of that information. It doesn't mean you have to provide what they're requesting in 10 days, but you have to acknowledge the request within 10 days. To your point, yes, we can do this. We will need time to get it done. We will comply as quickly as possible, or no, we can't get it done in the, in this time frame or in any time frame, and here are the reasons why.
Right. But here's another option that we can provide to you. So the information blocking rules are, it's not a blanket no. It's this isn't feasible, but here is what is feasible. So it's what you want to hear from your corporate compliance officer or your legal counsel. The answer can't always be no. It has to be, I understand what business purpose you're trying to accomplish. Let's work to get there.
Got it. And again, it comes down to defining what feasible is. So very important. So I got two more questions for you on information blocking, and then I want to transition over to really more of a pure HIPAA conversation for the next, little bit that we have together. One, what are the fines that an organization or an individual can face for violation of the information blocking rule?
Great question. So just like we saw HIPAA increase their fines over the last few years, the fines are substantial here. So for health information exchanges and networks, the fines are up to $1 million per violation. Now, the fines for healthcare providers have not been published yet, but when the benchmark is $1 million for health information exchanges and networks, and we know that for HIPAA, we're in the six figures as well, I expect that those fines will be substantial.
I agree with you. I mean, just last year, I had a group that, they were hit with the second largest fine in HIPAA ever, only behind Blue Cross Blue Shield. I think Blue Cross Blue Shield was like 15 or 16 million. My client, and she actually came on one of my podcasts, Teresa Tollerson, and she was talking about, I think the original demand was like $13.6 million that the Office for Civil Rights wanted for a breach that wasn't even the fault of their practice. The breach occurred with their third-party vendor. Mm-hmm. And it wasn't like somebody hacked their system. This cyber terrorist organization, referred to as the Dark Overlord, I try not to laugh, because it's not a joking matter, but anytime I say their name, I always think about Chris Pratt in Guardians of the Galaxy, where he says Star Lord. So this is the Dark Overlord. And, but they're no laughing matter. This is the organization that hacked Coca-Cola, FedEx, Disney World, Fortune 100 companies. They're no joke. And they're actually now hacking a lot of hospitals, physician medical groups that are tied to universities. You all, folks, you would not believe how many teaching physician organizations or faculty group practices tied to major universities are being held hostage right now for ransom from these cyber terrorist groups. They're not publishing it, but if you look at the dark web, the number of listings for available protected health information, financial information, it's running rampant. I mean, it's absolutely mind-boggling to me. But anyways, So the fines can run up to $1 million.
Right.
And my guess is if it's egregious enough with a physician's group, they're not going to hesitate to throw out $1 million fine or something close to that to get
They're
the
going to
rest
be
of the
consistent
industry.
with HIPAA, right? I mean, they're going to use that as precedent and
Yeah.
as an example. And I think the first couple cases, they're going to be looking to set the stage and set the example that this won't be tolerated. I mean, look at where we've evolved to get here. And again, remember what the purpose is behind the rules. And so when you talk about cybersecurity, just a really quick statistic that I heard yesterday from my broker friends is that only about 20% of providers that are quoted cyber liability insurance will actually purchase it. And the ransomware, the bad actors, the dark side of the web, they're targeting the smaller providers now. So we had a lab that only has, a handful of employees and maybe does not even a couple $1 million a year, get attacked and held, with the ransomware, because those are the ones that are letting their guard down. They're like, we're too small. Well, no, you're the ones that don't have cyber liability insurance and don't have the policies and the protections in place. So that's just another helpful tip.
Yeah. And I also, Amanda, equate that to a conversation that we have all the time where I have providers say to me, I live in rural USA. I'm a one doctor practice. You really think Medicare or Blue Cross or UHC is paying attention to what I'm doing?
Yes, they
are. Absolutely. Yes.
Yes, they are. They have machines that just.
Yeah. I mean, I don't care that you're a one doctor practice. You spit out 13,000 RVUs last year. Yes.
Right.
I think the government's looking at you.
Right.
All right. So here's my last question to you. Since we were talking about fines, we've talked about policies. In your legal opinion, do you believe that having an effective policy on information blocking in place prior to somebody raising a grievance against your organization, even if the organization was complying, but somebody was just not doing the right thing, do you think that having an effective policy in place will help to lower or lessen the financial blow that an organization could face for a potential fine for violation of the rule?
Sean, I always tell you could be an attorney with that leading question. Of course, Sean. We know that, when, these agencies have discretion to implement civil monetary penalties, and it depends on the level of intent. So if the organization showed a working knowledge of, we knew that these rules were in place, we knew that we had to comply, we had a policy, we trained on it. Hey, it was this person that didn't listen to the rules, didn't listen to our policy, then the level of intent goes down. And so does the civil monetary penalties in most cases. So I agree with you. Oh, are you on mute, Sean?
It's always good to have somebody like yourself agreeing with me, because not many people actually do. So I'm going to take it anytime I can.
I had to laugh at the leading question.
I wouldn't do well as a trial lawyer. I'd have objection after objection.
Perfect. No, that was a nice close to that. It's perfect.
Good deal. All right. So now I want to transition over to HIPAA. Okay. To a pure HIPAA conversation. And folks, please, if you're on and you were staying on for the information blocking, please don't disconnect right now, because I think this conversation is just as important as the conversation that Amanda and I were having about information blocking, because there is a world of misinformation out there. I want to start by talking very quickly about vaccines. There are a lot of misperceptions. People are out there saying the government, employers, they have no rights. They cannot enforce, they cannot mandate individuals getting a vaccine. True or false?
That is false. Employers can require employees to get vaccinated. There are two exceptions. One is a religious exception, and the other is a medical exception. And it's an application process. So if you're an employer that's thinking about mandating the vaccine as a condition of employment, continued employment or initial employment, you need to have a policy, and you need to allow individuals the opportunity to present a request for accommodations to that policy, which would be the religious exemption or the medical exemption. And you've got to engage in a review process similar to what you would do under the ADA for accommodations. So if you're thinking about this as an employer, make sure you have a policy and make sure you follow it.
Yeah. And the DOJ issued, I believe it was back in July of this year, they issued their opinion to basically come out and say that the federal government has the right under the Public Health Emergency Act to mandate individuals getting vaccinated.
Right.
Look, we talk about the fact that it is personal choice. I'm a proponent for, people having the freedom to make the choice that's best for themselves and or their family. And there's no buts. I'm not about to give a but. Just take into consideration, in order for our country or for any country to reach a herd immunity, you've got to have 90% of the population vaccinated. Again, I know there's a lot of concerns. I think the messaging that's come out from all sides of the spectrum on this public health emergency and the importance of vaccination or why you shouldn't get vaccinated, I think the messaging has just been problematic from the get-go. And it's not gotten any better with the messaging that came out, in my humble opinion, from Dr. Fauci just on Monday. But y'all can watch his interview and make your own determination on that. So here's where it starts to kind of, so we've talked about the fact that employers have the right to mandate vaccines.
Correct.
Whether you're an established employee to the organization or you're being onboarded. Right. However, they have to make accommodations if there is a religious aspect that would preclude somebody from, just like, individuals have a religious preference that there should be no heroic measures initiated, right. and that's their right under their religious beliefs. Or if you are a protected individual under the Americans with Disabilities Act. Those are the two exceptions to individuals not having to comply with a request or a mandate from either the government and or their private employer.
That's right.
Okay, cool. Now, vaccine cards. Okay.
Okay, so vaccine cards. Employers have the right to request a copy of your vaccine card or request you to confirm or deny your vaccine status. They have the right to ask that question.
Okay. And the reason why they have the right to ask that question is because
it is not protected information under HIPAA. Employers are not subject to HIPAA.
That's right. So, folks, this is mind-boggling to me. Okay, folks, I know there's a lot of people on listservs, and I'm sure some folks are going to be angry with me after this podcast because there's always at least one who's angry with me, and I'm okay with it.
Right, and these aren't personal beliefs, right? We're just stating the state of the law.
Yeah, this is the law.
Right.
This is coming. Forget about me, okay? I'm not important here. This is the 2022 best lawyer in America for healthcare, okay? This is not Shawn Waesch. This is Amanda Waesch telling you this. They are not subject to the rule.
Right.
Now, folks, again, if you are getting ready to travel internationally, be prepared because the airline will ask you for a copy. They will ask you for your passport and they will ask you for your vaccine card. If you tell them they don't have a right to see that, you will not be boarding the plane. I just witnessed this coming home from a trip the other day.
Yeah.
If you out of San Diego, if you tell them I'm not giving you my vaccine card or it's none of your business, you will not board the plane. I guarantee you could kick and scream and yell and complain all you want. You're only going to cause them to call the police to come and escort you away from the desk.
Right.
So
it's not a HIPAA. It is not a HIPAA right.
Yes. Now, let's talk about, for just a minute, whether, let me rephrase this. Here's that legal aspect. Let me rephrase the question. Could state privacy rules differ from what people are hearing? And maybe that's where the misperception or miscommunication is coming from.
Right. So when we talk about federal rules, employers can inquire as to vaccine or vaccination status. And again, it's not a HIPAA right for you as an employee. But I will say that the information, when you give it to the employer has a duty to maintain confidentiality. So the employer can't share your status with others or disseminate that. It's just for them to use, for their purposes. They have to keep it confidential, just like they need to keep other information that you disclose to them confidential, IDs, social security numbers, things like that. So state law could differ. And so we could see some differences based on the state. So for example, I'm sitting in Ohio and we have a law that says public universities, public employers, public universities and colleges, we can't require students to vaccinate, and we can't ask them about their vaccination status, and universities and colleges can't discriminate against these individuals based on their vaccine status. So what we're seeing in Ohio is the schools are just saying, okay, well, we're just going to do a mask mandate for everyone because we can't ask whether you're vaccinated or not. So there could be some state law nuances there. We could also see some nuances since Pfizer has just now been approved. We could also see some nuances in employers' policies where, vaccines were mandated only for an FDA-approved vaccine. Well, now that Pfizer is approved, we have an FDA-approved vaccine. So you're going to want to look for nuances there, and you're going to definitely want to talk with your Labor and Employment Council on those nuanced questions.
I think that's an excellent point. Mm-hmm. All right. So I think we've covered in depth more than I think I found anywhere else recently on information blocking and talking about the mandate for vaccines and the vaccine cards. Anything else in closing that you want to leave for our listeners as a takeaway message, things that they should be doing or things that they should be watching out for tied to information blocking and or the vaccine mandates and the vaccine cards?
Sure. So when it comes to information blocking, don't stress. Take the approach, kiss it. Keep it simple, right? And I won't do the last S. But, your policy doesn't have to be 30 pages, right? You can, so it's a simple policy that's incorporated into your corporate compliance policies that you educate and train on. Don't stress about it, but be aware of it. When it comes to vaccines and, if you're an employer and you're not sure, what to do, you definitely want to know, what does your state law say? We talked about federal law here, but you're going to want to be, consistent with other employers around you. And you're going to want to meet your business needs in making your business decision. And again, have a policy and implement it consistently.
Yeah, and make sure when you create the policy that it just doesn't go into your policy manual. Make sure that you actually educate your staff. As a compliance officer, I always like when we create a new policy or we make a significant revision to a policy that's already in place that could cause questions or cause concerns. I always make sure that we distribute it to the employees, to the staff, have them read it, review it, ask all of their questions, make sure they understand it, they're satisfied with the explanation that they've been given, and then I get them to sign a copy of that policy. And I give them a copy back, and one goes into their personnel record. That way, if down the road somebody says, well, that's not what you told me, well, here's an actual copy of the policy that you signed. So it's sort of a CYA as well.
Sure.
So, all right. So, Amanda, let people know where or how they can get in touch with you if they receive notice from a governmental payer or commercial payer, or they have the OIG knock on their door or the FBI knock on their door and they need somebody who's a health care centered attorney, who's a litigator, who can help defend them. Let people know how they can get in touch with you, please. And I'll make sure I put it into the description of this podcast today as well.
Thanks, Sean. So my number is 330-253-9185. And my email address is AL, my last name, Waesch, WAESCH, at bmdllc.com. And if you call me, I will always co-counsel with Sean and his team, the best team around.
Thank you so much for that. All right. Well, listen, ladies and gentlemen, as always, thank you so much for tuning in to another episode of The Compliance Guy. I want to take a moment to again thank my very special guest, my very good friend, Amanda Waesch. With everything that she has going on in her life, I'm so humbled that she's willing to take time out of her schedule to chat with me and to do these live sessions. So, Amanda, thanks again for being here today. I know our listeners greatly appreciate it. I greatly appreciate it. I learned several new things today, and I'm guessing they have some great takeaways as well. Again, folks, we'll be back with another live episode of The Compliance Guy in the next week or so. Stay tuned to LinkedIn, YouTube, and Facebook for our announcements. Again, my name is Sean Weiss, and I promise I will try to do better next time. But until then, take care of yourself, and more importantly, be good to each other. Bye for now.